anymore, or it was never really determined. It was a hearing that you had with, is it called Reed Stevens, with
Good morning, Mr. Anderson. Are you on?
Yes, I'm on.
Okay. Okay, thank you.
Thank you, ma'am.
All right, good morning. It is 8:55 a.m. on August 27, 2025. We are here to adjudicate one case. That case number is 25496. It is Alpha Energy Partners 2 LLC. Entry of appearance, please.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen Shield, appearing on behalf of Alpha Energy Partners 2 LLC.
Good morning, Mr. Examiner. This is Warren Anderson, Lily Anderson, appearing for case number 25495.
Mr. Anderson, I have 25496. Do you
Yes.
concur?
Concur, sir.
All right, good morning.
Good morning, sir.
Good morning, Mr. Examiner. Dina Bennett from Model Sperling on behalf of the City of Carlsbad and also on behalf of Coterra Energy and its affiliates.
Good morning, Ms. Bennett. What is your position, your client's position in this case at this time?
At this time, we're only monitoring the case and preserving rights.
Thank you. Ms. Pena?
Good morning, Mr. Hearing Examiner. Yaritza Pena with Hardy McLean on behalf of ConocoPhillips Company, and we're also just monitoring and preserving rights.
Thank you. And then, Mr. Savage, do I see your witness on the screen here?
That's correct. Mr. John Kaufman is the landman expert witness, and Mr. Jason McLean is the expert geologist.
And is Mr. McLean here with us too?
He is, and both have testified previously.
Perfect. Let me get them both sworn in first. Would you both raise your right hands, please? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
I do.
All right, very good. Let's start with you, Mr. Kaufman. Would you state and spell your name for the record?
John Kaufman, JOHN COFFMAN.
And what is your field of expertise?
Petroleum land management.
Okay, and you've been recognized by this division in that expertise?
Yes, sir.
Okay, very good. Mr. McLean, your turn.
Yeah, my name's Jason McLean, MCCLAIN, and I'm recognized in the field of geology.
By this division?
Yes, sir.
Okay, all right, very good. Okay, so Mr. Savage, why don't you present your case and then we'll go to cross-examination.
Okay. So the first witness I call is Mr. John Kaufman, landman for Alpha Energy.
Don't you want to get your exhibits admitted?
I was going to do that as part of
Fine.
asking him about that he reviewed the exhibits and
You do, you're on.
you know, this
right
is
ahead.
a little unusual, but you know, I'll do my best to negotiate this. So, Mr. Kaufman, have you provided and reviewed, and are you fully familiar with the written testimony and land exhibits that were submitted to the exhibit on July 31st on your behalf?
Yes, I am.
Do you find them to be accurate and truthful to the best of your knowledge and understanding?
Yes.
Mr. Hearing Examiner, I ask that land exhibits A and all sub-exhibits be admitted into the record.
Okay, are there any objections? Okay, I don't hear any objections, so the A exhibits, the tab 2 what I see here is tab 2 is admitted as evidence in this case.
Now, Mr. Herrington, do you want me to address the good faith because that deals with the landman's testimony, or do you want me to go to the geology exhibits and enter those as well?
Yes, please.
Okay, the geology exhibits. Okay. I call Mr. Jason McLean, the geologist, to address the geology exhibits. Mr. McLean, are you available? Okay.
Yes, I
Mr.
am.
McLean, have you provided and reviewed and are fully familiar with the written testimony and the geology exhibits? And these are exhibits B and all sub-exhibits that were submitted to the division on your behalf?
Yes, I am.
And do you find them to be accurate and truthful to the best of your knowledge and understanding?
Yes, I do.
Mr. Examiner, at this time I ask that exhibits B and all sub-exhibits be admitted into the record.
Are there any objections? Not hearing any.
Could I would like to not object, but what are the exhibits? Do they read them out?
Okay, Mr. Anderson, I'll deal with that in just a moment. So not hearing any objections, these are admitted into evidence. Mr. Anderson, there were exhibits filed in this case back on July 31st, about almost a month ago, a little over, July 31st, almost a month ago. And
Okay.
I trust you said you know how to use the imaging system.
I think I said I did not know how to use it.
I understood you the other day to say that you understood, and I thought we sent you a link to the imaging system. Is that true, Freya?
Okay, I know what you're talking about now. I did see.
Okay. If you did use that link, it would take you where you could find this case and you could see all the documents, including yours, that have been filed in this case. And okay, good. And if you look at the document filed on July 31st of this year, there actually are there are many documents filed on July 31st. The one I'm looking at is the one, and they don't have titles, unfortunately. This one is the largest of the documents. It's basically 10 megabytes large. It's the last July 31st filing before we got your filing on August 5th. And that document is the exhibits we're talking about now.
Okay, I got it. I remember. I looked at them.
Okay, wonderful. And the exhibits have been admitted into evidence. So you can use any information in the exhibits to cross-examine the witnesses, or you can just cross-examine the witnesses from your own evidence that you filed as well. So I'm going to keep moving on and we'll give you opportunity at the appropriate time, okay?
Yes, sir.
All right, so Mr. Savage is presenting his case in chief. He's brought two witnesses on his client's behalf. And that's where we are right now. We're hearing the case in chief here.
And Mr. Examiner, there's a couple more exhibits we should admit. I draw your attention to Exhibit C in the case that provides a self-affirmed statement confirming the mailing of notice letters and notice by publication. Notice was timely mailed on July 17, 2025, and timely published on July 19th, 2025. And I ask that Exhibit C and its sub-exhibits be accepted into the record.
Okay. Mr. Anderson, the motion before the tribunal is to admit tab 4, which is Alpha Exhibit C, the self-affirmed statement of the attorney and the notice letters, mailing lists, and affidavit of publication. Is there an objection to receiving that into evidence?
No, sir.
Okay, very good. Okay, your tab C or your tab 4,
Okay.
Exhibit C is admitted to evidence. So far, we have Exhibit A, B, and C admitted to evidence. We don't have anything about tab 1, but maybe that's not evidence anyway.
That's all reference.
Sounds good.
But there's one yesterday, Alpha filed rebuttal exhibits 1, 2, and 3.
Okay.
I ask that they be admitted into the record
Okay.
as well.
And you sent those to Mr. Anderson?
That's correct.
All right, very good. And by email?
Yes.
Okay, very good. So, Mr. Anderson, yesterday you might have received from Mr. Savage an email containing some rebuttal exhibits.
If if I did, I don't remember.
Mr.
Yeah.
Savage, why don't you just describe what those exhibits are for Mr. Anderson?
Okay. So, Mr. Anderson, Exhibit 1 are the well proposals that were sent to you. Exhibit 2 was a chain of about approximately 23 emails that you and Mr. Kaufman engaged in, copies of those. And then Exhibit 3 is a copy of a lease that it looks like was marked up during discussions of the terms of the lease.
So your exhibit is from 2024.
So the exhibits have different dates. For example, the well proposals that were sent were in 2025, April and June. The emails span the course of a number of dates prior to the hearing, and you can see what those dates are. There's a number of them. And
Excuse not to cut you off, sir, but what you're talking about, that was in the first, that was 24, case 24, case 24944, when we received that first lease. But is that what you're talking about?
yeah, it's the lease. It was it looks like it was dated. Let's see here.
Because
Looks like it was around August 8th, 2024.
right.
That would be Exhibit 3 that we are providing for discussion.
Okay.
Okay, so Mr. Anderson, the question to you was, are there any objections to the admission of the rebuttal exhibits that he just described to you?
I do object to using that, but if they want to use it, they can use it. But the way they presented it in 2024 or in that case number 24944 was wrong.
Mr.
So-
Anderson, you can cross-examine the witnesses if you see that's where you have an opportunity to point out any discrepancies or things in your favor. I think I want to remind you that the issue today, the issue that you have raised, the objection you raised was based on what you claimed was a lack of good faith negotiation. Do you remember that?
Okay. Yes, sir.
Okay, good. Are there any other issues that I'm not aware of, or is that the sole issue before this tribunal today?
Well, I don't know if you're aware of the I believe it's the APPL, the AAPL. That deals with the 1989 modified that I objected to in my reconsideration lease. I thought that would be the lease at hand, not the 2024 lease.
Okay, but Mr. Anderson, what I'm trying to understand is the scope of the objection. Is that not still, now you have to understand something before I say anything else.
Yes, sir.
This tribunal does not have jurisdiction to weigh in on lease terms and private conveyances between parties. The issue of good faith before this tribunal is the issue that we have jurisdiction over.
Okay,
There are seven
I-
factors. There are seven factors that the division looks at when it comes to granting a compulsory pooling application. Good faith negotiation is one of those factors.
okay, okay.
So is your objection, even considering what you just talked about, the APPL, I'm not even sure what that means, but does that go toward the issue of good faith?
Yes, because, before they even, sent out, they say in good faith, and in negotiations, they, and it's just a lot of red flags in the negotiation process that they put into the lease that they sent, and
Okay.
then to be able
Oh.
to pull me and get me to this point. So they never was dealing in good faith,
Okay.
and they never, okay.
Okay, I understand, but this still all revolves around the issue of good faith negotiations. So I don't hear an objection to the rebuttal exhibits, which is really where we are right now in the hearing. We're just dealing with evidence that has been submitted, and we're going to get to your evidence in just a moment, okay? So
Yes.
Mr. Savage, not hearing an objection, your three rebuttal exhibits are admitted, and if you do refer to them, will you please refer to them as rebuttal exhibit 1, 2, or 3?
Yes, yes.
Now, Mr. Anderson, we have a motion before us that we have to deal with as a preliminary matter.
Yes,
So I'm hoping that you received that motion that was filed the day yesterday or the day before. It also included copies of the rebuttal exhibits that were later submitted on their own. So, Mr. Savage, just take a minute or two. You don't have to go over the whole thing, just a minute or two, and just in plain language, what are you asking the tribunal?
Well, in that particular motion, at the time that I filed it, I just asked for the admission of those exhibits. So I think that has been satisfied.
Okay.
I think if we can first address the good faith issue
Okay.
and then go on to considerations for the technical examiners
Okay.
of the remainder of the packet. But I think the questions I have will basically cover the content of the motion.
All right. So, Mr. Anderson, a motion was filed, which is basically moot at this point, which means I don't need to deal with it any longer. Mr. Savage had filed a motion asking for the admission of 3 rebuttal exhibits, but as they were offered into evidence and not objected to, they're in evidence now. So the motion is moot. All right, Mr. Savage, go ahead.
And just to clarify on that, I do think the content of that motion is informative to the OCD.
Okay.
So, okay. So I recall Mr. Kaufman as a landman expert witness. Mr. Kaufman, have you read and reviewed Mr. Anderson's pleadings in this case? That would be his declaration that was filed on August 25th, 2025, and his letter filed with the OCD on August 21st, 2025.
Mr. Kaufman, before you answer that question, which is an easy answer, but before you answer that question, let's get these admitted into evidence as well. So, Mr. Anderson, let's deal with your submissions, okay?
okay.
Because I think this is a good time to do that. So, first of all, I need to know exactly which documents you're seeking to admit into evidence, because I have a bunch of documents all filed within the last week that look a lot alike. So I'm going to go to the most recent one and we can work backward. I received a document. I received a document that's called a Declaration of Respondents. I received this document on the 25th, which was 2 days ago at 3:13 p.m. That you sent by email. It's a 4-page document.
Yes,
Okay, good. Are you seeking to have this admitted as evidence?
yes,
Okay. Now, just so you know, this is an affidavit, which basically swears to the truth of the statements in the document
yes,
under penalty of perjury.
yes. I've been saying this since the first since the first hearing that we ever had. I've just said the same thing.
That's okay, but this is now, we're talking about evidence here. This is now sworn, this is going to be sworn testimony, not just statements you made in argument.
Okay,
Now, for me to accept this, I'm going to swear you in, and then I'm going to ask you to adopt this under oath. So would you raise your right hand, please?
yes,
Mr. Anderson, is it Warren Anderson, by the way?
yes, sir.
Okay, Warren Anderson, do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
You do? Is that a yes?
Yeah, yes, sir. Dealing
Okay,
with what I've sent in from day one. Yes.
that's not the question, sir. So you do swear and affirm that you're going to tell the truth and nothing but the truth, right?
Yes, sir.
Okay, very good. Now, this document, this 4-page document that I just referred to, do you have it in front of you?
Yes, sir.
You do have it. Okay, very good.
Yeah.
And do you adopt this document under oath to be completely true and free from any falsehood?
Yes, I do.
Okay, very good. So this document is now in evidence, Mr. Savage. Let's go on to see what else Mr. Anderson has filed. And I have to just click on each item here.
Yep.
So hold on a minute. Okay, so Mr. Anderson, I have something received. It's a 3-page document on the 21st of August, also by email, to where it begins, to whom it may concern. Alpha Energy Partners have no permission to do any operations. Do you know what document I'm talking about?
Yes. Yes, I do.
Okay, and it looks like there is something I can't really read. So unfortunately, the table that you have on page 3 is illegible. You cannot read it. However,
It's just that's just the table of these figures that was prepared by Paloma Permian
okay,
Asset LLC.
I understand. That's fine. So
Okay.
maybe we'll see it in the exhibits that Mr. Savage has submitted into evidence. So maybe that part is already in evidence, but I'm going to ask you to adopt this 3-page document under oath in the same way I asked the other one.
Yes, sir.
All right. All right. So you've sworn to this document. Now let's go on to, I think, a document that you filed. I know I saw a document with a lot more pages than this. Freya, was that submitted back on the 5th of August?
Yes, there's another one on the 5th.
It looks like there's several on the 5th.
If you're looking in imaging, it's the one that has the number 586.
Okay,
KB.
thank you. Let me find it. If I'm in imaging, that has 586. Okay, I see. It's the larger one. That makes sense. Okay. Mr. Anderson, I have another document. Well, no, this is a 4-page document. This is going to be similar. I think this is a 3-page. I know I saw a longer document. Freya, these are not the ones I'm thinking of.
Yes, sir.
Mr. Anderson, didn't you send us about a 25-page document? Where is that? Where is that, Freya? Hold on, Mr. Anderson. I'm wondering whether
Yes,
it was not submitted into imaging.
I see two from August 5th from Mr. Anderson.
Right.
Those are shorts.
I'm looking to the one that has, I just saw it this morning. It had notes written on a well proposal. It had emails.
Yes. I sent that in 20, is that's what they introduced into, evidence? The lease agreement that they sent, that I received from, Lake Onshore, landman Miss Nelson. From a Miss
You know what,
Nelson.
Mr. Anderson, I think I understand my mistake here. I think it was Mr. Savage who submitted the emails and the as rebuttal exhibits. That's what I'm thinking of. So, okay, I think we have your exhibits in evidence. I don't think we're missing anything that is relevant. So we have two documents in evidence now. One is 4 pages, one is 3 pages. Is that your evidence, Mr. Anderson?
One is 4 and one is 3. Yes, sir.
Okay, and then of course, we also have your emails that Mr. Savage submitted along with some notes you wrote on a well proposal and other documents. So that's also evidence that's in evidence. Okay, Mr. Savage, why don't you go on and put on your case? You asked Mr. Kaufman a question that I interrupted.
Yeah, that's fine.
Do you want to ask it again?
Yes, Mr. Kaufman, have you reviewed these two documents that were just submitted into evidence by Mr. Anderson?
Yes, I have.
Does Mr. Anderson's declaration show that Alpha engaged in negotiations with him and Ms. Anderson in an effort to reach an agreement about their mineral interest?
Yes, it does.
And does Mr. Anderson's letter filed August 21st also show that Alpha engaged in negotiations with the Andersons in an effort to reach an agreement about their mineral interests?
Yes, it does.
Now, Mr. Kaufman, are you familiar with the 3 rebuttal exhibits that were filed on behalf of Alpha? Rebuttal exhibits 1, 2, and 3?
Yes.
What is rebuttal exhibit 1 and what does it show?
Rebuttal Exhibit 1 is the proposals that were sent to Bobby Anderson and then Lillian Warren Anderson for the Hollywood Star 1718 FECOM 503 and 553 wells.
And there are two well proposals. Is that correct?
Yes.
What does the second one
The
show?
The second one shows Lillian Warren Anderson. So we had originally sent one to Bobby Anderson since there was no record of probate. And when Warren had reached out and said that Bobby Anderson was deceased, we then sent them Lillian Warren a proposal as assumed heirs of Bobby Anderson.
So Bobby
Okay.
Anderson was the owner of record?
Yes, sir.
Okay. And what is exhibit 2 and what does it, rebuttal exhibit 2 and what does it show?
Exhibit 2 is the email correspondence between me and Mr. Anderson trying to negotiate terms of the lease.
And what time period was that over?
I think it'd be over the last year.
Okay. And about how many email exchanges did you have?
Over 30. I think somewhere close to 37.
Okay. What and is it true that in the sample that we provided that there's approximately about 23 in there?
Yeah.
Okay. And what is exhibit 3 and what does it show?
Pull it up here. Exhibit 3 shows the well proposal and the lease that was sent to Mr. Anderson. Let's see if I can pull it up.
Is exhibit 3 in front of you?
Are we talking about rebuttal exhibit 3?
Rebuttal exhibit 3.
If you could be clear, Mr. Savage.
Yes.
Yes, rebuttal exhibit 3 is the oil and gas lease that we had sent to Mr. Anderson, the memo of oil and gas lease.
And whose handwriting is that on the on that lease?
I believe it to be Mr. Anderson's.
Mr. Kaufman, how long have you been involved in leasing and purchasing minerals in the area in which the subject lands are located?
In New Mexico as a whole, about 10 years, and then in these subject lands, about 2 years.
And do you have knowledge and understanding of the fair market value of mineral interests in this area based on your experience?
Yes, I do.
And what did you offer Mr. Anderson in your efforts to reach a voluntary agreement?
Our final offer was a $5,000 flat bonus payment, a quarter royalty for a 3-year primary term lease with a 2-year option to extend.
And was this offer above or below fair market value for leasing his mineral interests?
This would be above.
Mr. Hearing Examiner, I have no further questions.
Okay, Mr. Anderson, it's now your time to ask this witness, who is the landman expert from the applicant, questions that are within the scope of his direct testimony and within his experience. Go right ahead.
Okay. Mr. Kaufman, you say you sent out a lease or paperwork to Bobby Anderson. And that's correct. But Bobby Anderson is deceased, and and I believe that he was deceased because in the first hearing, and even before the first hearing,
Mr. Hearing Examiner, I'll object to this. Is there a question involved?
So, Mr. Anderson, I want you to be I want you to understand the process here.
Okay.
Right now, you are cross-examining the witness. You will have an opportunity later, if you so choose, to present your own evidence beyond the statements that you made in these 2 documents that we have admitted into evidence already. But right now, you're not introducing any evidence into the record because you're not the witness, and only what the witness says is evidence. So your questions are to bring out any new evidence that you want us to consider, but it has to be from the witness. So do you understand?
Yeah.
In other words, if you think this witness is not telling us the whole story, ask him questions so that we hear the other side of the story, the side of the story that you believe shows bad faith.
Okay.
Go right ahead.
All right. Mr. Kaufman, I would like to know how you believe that you are operating in good faith.
We had sent out well proposals to all of the interest owners within the south half, north half of section 17 and 18. Bobby Anderson's estate was never probated in New Mexico. So as we look through title, there has to be a probate that transfers the interest from Bobby Anderson to his heirs. So that was where the original proposal went. And so within our proposal, we offer the ability to either lease, participate, or sell interests for each working interest owner within the spacing unit.
Mr. Kaufman, you say you checked the OCD files or the register deeds and who was on the deeds to find this out?
It would be at the county clerk's office in Eddy County.
So if you did that, because there was, what I'm going to say is there is probate and it has been switched over.
Objection. Is there a question here? Thank you.
Mr. Anderson, again, you
Yes.
switched into a different mode, and you've got to remember that your role right now is just to ask questions. You're not trying to introduce new evidence.
Okay.
You'll have that opportunity later. Do you have any questions for this witness? Do you have any further questions for this witness?
I would like to ask John Kaufman, who represents Alpha here as their landman or their contact person, if you ever plan to do a feasible lease with the Andersons.
Absolutely, we'd love to lease your interest.
And if so, why has it taken this long for you to come to a feasible resolve? Because yes, that's the question.
I think our offer as it stands is a feasible and fair offer for your interest.
Do you think by using and invoking the 1989 modified from the APPL form, and what you guys did in doing so was in good faith?
So we currently do not have a JOA or operating agreement with you or this interest. We provide the 1989 AAPL form operating agreement to parties that would like to participate in the wells that we proposed.
And is it true that the landowners who don't go along with your proposals and lease that you use unfair tactics by unfair tactics and abusive and things that would burden the landowner for not going along with you?
No, we would file for compulsory pooling like we have in this case, and we would then propose the wells under the orders to the working interest owners that have not elected to participate or are unleased.
Mm-hmm. So do you think it's fair to pull a landowner who's trying to deal with you guys and get the best for his land, which is his land and not yours?
Could you repeat the question?
I said, do you think it's dealing in good faith, or is it fair for you to ask the OCD prematurely to pull a landowner who's been trying to deal in good faith with you as a landman and a representative of Alpha and Permian?
I think the negotiations that we have communicated and are filed in our rebuttal exhibits have been very fair and above market price for your interest. And I can't speak to the rules of the OCD. And if I think those are fair, they're just the rules that we follow.
I mean, So my question is, we're all following the rules of OCD. But my question to you now is, have you put a twist on the rules when it comes to the landowners who don't agree with what you're trying to do?
No, sir.
And my my last question is, do you think that you have dealt in good faith by sending out each of your leases in Bobby Wayne Anderson name only when you knew that he was deceased?
That's who the title shows to be the owner. So that's how we have to follow the rules. And where the interest is located and who owns it, that's how we propose. And that's how the lease will be styled.
So I ask you again, when you went to the recorder's office, you saw Bobby Anderson's name, and you saw, and you're saying that you saw no mention of Lily Anderson on the paperwork with the OCD or the recorder. You saw her name nowhere. And all you saw was Bobby Anderson.
We have proposals to Bobby Anderson and Lillian Warren Anderson in our rebuttal exhibit.
Sir, if you have, because that's not, the question I'm asking you is, why have in every thing that you sent us out first is just in Bobby Wayne Anderson's name, and we don't answer that because he's been dead for over 20 years?
Objection, it's been answered.
Mr. Anderson, you have asked that question several times, and I don't think the answer is going to change at this point. I have the answer to that question in my head that you've brought out. So do you have another? I think you said that was your last question. So are you finished asking this witness questions?
Yes.
Okay. Mr. McClure, do you have any questions for Mr. Kaufman?
Mr. Hearing Examiner, I do have questions for Mr. Kaufman.
Go right ahead.
Mr. Kaufman, in the title review that you conducted that showed that Bobby Anderson was the owner of this unleased mineral interest, when was that conducted?
Within the last year. I'd have to get my files out to figure out specifically.
Was this the same title review that was involved in the Wolf Camp formation version of this unit?
Yes, sir.
So then the title review has not been conducted. Would it be accurate to say that you don't believe title was conducted since October of 2024 then?
There are a lot of mineral tracts in this development, so it's an evergreen process.
I apologize. Say that last bit one more time.
It's an evergreen process, so we're constantly updating title as new information comes in.
Can I ask, what does that mean?
No, Mr. Anderson, please just listen to the questions that the technical examiner is asking the witness. You've had your opportunity to cross-examine, so please don't interrupt at this point.
Yes, sir. I will.
Mr. McClure?
Thank you, Mr. Hearing Examiner.
You were clarifying that answer, I thought?
I was thinking about, well, no, well, I mean, I understand what his answer was, but I can ask again, I guess.
Ah.
So, to clarify, when you mentioned evergreening, is it correct to mean that it's an ongoing review of title?
Yes, sir.
Was consideration done to reviewing Bobby Anderson's unleased mineral interest, considering that we have testimony that he's now deceased?
Yes, so that has not changed. There has not been a probate that we've been able to find in the New Mexico records that shows the estate of Bobby Anderson being probated into Lillian Warren.
Well, maybe I misunderstood your earlier answer then. Is it correct that that the title for Bobby Anderson was not reviewed after October of 2024?
Correct.
Prior to October 2024, were you aware that Bobby Anderson was deceased?
No, I was not.
Okay, so I guess backing up to my prior question then, after you were aware that Bobby Anderson was deceased, was there consideration to reviewing that title?
Yes, and it's still in his name. Like it was reviewed in October. There's from October to present, there has not been a probate filed for the estate of Bobby Anderson.
And you have to forgive me because I'm not a landman, I guess, but does that mean that you have since October 2024 been reviewing and confirming that there's no additional filing for that then?
Yes,
And when was that last done?
I believe it was right after the Wolfcamp cases. We went back and checked if there was a probate. There was not a probate filed.
Now the Wolfcamp case, it was in March of 2025. Do you believe shortly after that was when you'd reviewed when you review the titles again for this?
That's correct.
Okay, thank you, Mr. Kaufman. In the latest lease agreement offer that you had provided to Mr. Anderson, you referenced a straight up offer of $5,000. Is that correct?
Yes, sir.
Does that include an additional $5,000 for the 2-year extension?
If we get to the 3rd year and we think it's necessary to extend the lease, then yes, sir.
Okay, thank you, Mr. Kaufman. Are you familiar with, I don't know if it might be easier for Mr. Savage to share it for us, I guess, make sure we're looking at the same thing. Mr. Savage, do you have the 821 document that Mr. Anderson had submitted it to the division? It has his term agreements.
Was that a rebuttal exhibit, I think?
If is that rebuttal exhibit 3
I think
that has the lease and the notes that Mr. Anderson included?
Well, I think he's kind of broke out a little bit in his emails here. Let me see. In your rebuttal exhibit, you have an older version of the document that I'm referring to, but it should work for purposes of my question. So if we can look at your rebuttal exhibit 3, I'm assuming.
Could you give, Mr. McClure, would you give Freya, who is doing the screen sharing today, the page number of 32?
31, please,
Thank
Freya.
you.
You said 31?
Yes.
Yes, ma'am.
Can you see it?
Yes, we can.
Oh, I see I'm sharing. I'm trying to share with Pecos Hall's computer, so let me just log in on my laptop. I think that might, unless you can, virtual people can see it, but
No.
in the room can't. Okay. Just 1 second.
I was confused because I was seeing it.
And Mr. McClure, is this the document that starts on page 30 of 32, to whom it may concern, et cetera?
That is correct. And actually, I did tell Freya the wrong page. It's 30 is the one I want, not 31.
That's fine. There you go.
Mr. Kaufman, are you able to see what Freya is sharing for us?
Yes, sir.
Do you see kind of towards kind of 2/3 down where it says Lisa asking for $10 per barrel of oil?
Yes, sir.
Is it correct that later on Mr. Anderson amended this to now be $1.50 per barrel?
That is correct.
In your experience as a landman negotiating lease agreements, have you ever seen a term similar to this?
I've seen a production payment with a time, like a term. It'll be something like $1,000, or it'll be $3 million. So it doesn't have a per barrel cost. It'll be $3 million as it comes out of the well. And then once it hits $3 million, then it would stop. But a per barrel price, no.
If you were to consider this as a royalty, have you done any calculations as to what percent of royalty this would equate to at $70 a barrel?
No. I had asked Mr. Anderson if this was a proportionally reduced number to try and calculate that and group it with the royalty. And I did not hear a response from him on that.
Is it your understanding that this is per barrel out of the well rather than proportional to the acreage that he holds?
That's correct.
Freya, could we switch to Alpha's exhibits? Should be a 399 page document. And then page 64. Oh, thank you, Freya. Mr. Kaufman, do you see on this table, it's your summary of contacts, your exhibit A4. Do you see on this table where it shows Bobby Anderson?
Yes, sir.
And then on the right-hand column of that row, it references an email receipt or an email that was received 7:30. You see what I'm referring to?
Yes, sir.
Is it accurate that this is the only email that's involved in the communication with, well, I guess Mr. and Mrs. Anderson at this point?
No, in our rebuttal exhibit, it shows the communications with Mr. Anderson.
Okay, were the additional communications or had the additional communications occurred at the time that this document was put together?
No, I believe this document was filed on 7/31. So up until that
Okay.
point, it was just.
Okay, so then or go ahead, sir, go ahead.
I said up until that point, I believe it's just a single email.
Okay, so then the emails that's in the rebuttal exhibits had all occurred after this exhibit was produced then, is that correct?
Yes, sir.
Okay, thank you, Mr. Kaufman.
Oh.
Mr. Anderson, we can hear the background noise, so Freya is going to
Okay.
mute. Freya's going to mute you. It'd be better
Yes,
if you it'd be better if you kept yourself mute until you need to speak. But anyway, I just wanted to let you know why you're on mute.
Yes, sir.
Thank you.
Mr. Kaufman, the addresses that I assume was provided to Mr. Savage for notice of this case, were those provided by yourself? Or are you aware, or are you familiar with that process?
Yes, sir.
Freya, if we could go to page 99. Thank you, Freya. Are you familiar with this notice spreadsheet, Mr. Kaufman, or was that Mr. Savage's office?
Yes, I'm familiar.
Okay. On those, you see on the right-hand column where it says mailed in red, do you see what I'm referring to?
Yes, sir.
Do you know what that is meant by that status?
I believe that's the status that is shown on the certified mail label mail out.
Okay, but you don't know what it means then, is that correct?
No, sir.
Okay. Freya, could we go to page 104, please? Mr. Kaufman, do you see again on the right-hand column where it says, it's a couple down, like 5 or 6 down, it starts saying like to be returned, no such number?
Yes, sir.
Do you know what that status means?
I believe that it was undeliverable and probably headed back to the post office.
How were the addresses attained for these, numerous peoples in this notice, and that had to be provided notice of this case?
So we usually look back on the last document.
Mr. Hearing Examiner, I'm going to ask for a point of clarification if I could. So the issue is good faith negotiations. And it looks like we're getting into an area where discussing the question of notice of the case itself. Mr. Anderson received notice. He made an appearance. So I don't think this is an issue that's in question. And I don't think it relates to the good faith issue.
Okay. So Mr. McClure, where are you going with this line of questioning?
I want to confirm how notice was conducted to confirm that the division could potentially issue an order for this case instead of having to have it be continued and hear it again.
Sounds like,
So this is part of a larger evaluation beyond the good faith. Okay,
Well, I
I'm
think-
sorry, Mr. McClure, you know, that's the whole case is under evaluation. So please accept my apologies and continue.
okay, so the objections.
Can I say
over-
something?
Okay,
Mr. Examiner?
yes, go ahead, Mr. Anderson.
On this line of question, it speaks to what really took place, because you said that the landman is saying that they satisfy the burden of proof. When the burden of proof, a dead man is not going to send you back any response, no matter
Okay.
how many times you send it out in his name.
Okay. Understood. Thank you, Mr. Anderson. So, Mr. McClure, the objection was overruled. Please continue.
Mr. Kaufman, just to re-ask my question, I guess, how were the addresses for these persons obtained?
We used a few different ways to get the addresses. So if there's an instrument filed in Eddy County for an interest owner, we will use that last address that was on the document if it's reasonably, within the last 5 years. If not, we'll try and use white pages and find new addresses for these folks.
Did Alpha conduct it themselves, this review themselves, or did they hire a third party?
We have brokers that helped us with the addresses.
Thank you, Mr. Kaufman. I have no further questions, Mr. Hearing Examiner.
All right, thank you. Mr. Savage, is there any redirect?
Yes, thank you. So Mr. Kaufman, you mentioned that you followed the rules of the divisions, the statewide rules regarding how and when to do a pooling procedure. Is that correct?
Yes, sir.
And is it fair to say you made multiple attempts to reach an agreement with Mr.
Yeah.
Anderson? And under your understanding, the agreement that the offer was fair and reasonable and well above market value?
That's correct.
And in the end, you were not able to reach an agreement. Is that correct?
Correct.
And is it your understanding, I know you're not an attorney, but is it your understanding under the pooling statute, your layperson understanding that at that point you have a right to initiate a pooling procedure?
Yes, sir.
I have no further questions.
All right. Do you want to call your other witness?
If it would be appropriate at this time, would it be appropriate, since we're dealing with the good faith issue, to make a quick closing statement, both Anderson and myself, to make a closing statement to sew that up, or do you want to do that?
Let's wait for a minute. Let's get Mr. Anderson. Mr. Anderson,
Yes.
this is your opportunity to put on your case. Now, I've sworn you in already, so if you want to make a statement of fact that is true about why, the evidence that you are presenting that good faith negotiations were not conducted, this is your opportunity to do that.
Yes,
But you
sir, I
will,
would like to.
but Mr. Anderson, I'll also let you know you will stand for cross-examination.
Yes.
Go right ahead.
Okay. So, Mr. Kaufman has stated that Lily Anderson's name is nowhere, and they couldn't find it. But Lily Anderson's name is on the OCD files and also in the county recorder files. We believe that Alpha Energy Partners LLC filled the compulsory pulling application against the property in Eddy County, New Mexico, under false pretenses by stating that they were not able to get in touch with us. The property owners, however, we have repeatedly emailed both Alpha Energy Partners and Legacy Onshore. We we advised John Kaufman by email and also called Mr. Kaufman to tell him that he knew that he needed to send the oil, gas, mineral leases in Miss Lily Anderson's name. He advised us that he would. Nonetheless, we received a compulsory pulling application filed from Alpha Energy Partners against our property. And now he stated that he didn't know, but I spoke to him and told him personally that, so how could he not know where to send and whose name to send it in? So I don't understand that. And I also told the first landlord, Miss Nelson, who lied and told me that I had to appear in front of the OCD when there was no hearing, because I had checked with the OCD and they said that because of weather, there was not going to be a hearing for a month or two, but they were still pressing and lying, saying sign the lease. So I'm just saying, after that, I don't know where the good faith started or the burden of proof. I've dealt and tried to deal above board with Alpha.
Okay, thank you, Mr. Anderson. Mr. Savage, any cross-exam for this witness?
May I do my closing statement?
That doesn't answer my question.
Okay. No cross-exam.
Okay.
Thank you.
Mr. McClure, are there any questions for this witness?
Yes, I do have a quick question, Mr. Hearing Examiner.
Go right ahead.
Mr. Anderson,
Yes, sir.
is it correct that you filed a document with the county courthouse changing the title over from Bobby Anderson to Lily Anderson?
Yes, sir.
When was that done?
That was done in the early 2000s. I don't remember the exact date, but I don't have the paperwork here in front of me, but I can get the paperwork and I can send it in to the OCD.
Okay, so at this time, you believe it was done in the early 2000s, is that correct?
Yes, sir.
But
My
you
father
don't
passed in the early 2000s, but we do have the paperwork where the probate has been done, and we pay the taxes, and I've been paying the taxes ever since.
Okay, thank you, Mr. Anderson. No more questions,
sir.
Mr. Hearing Examiner.
All right, thank you. So, Mr. Anderson, just to be clear about something. Unless you were going to make some sort of a motion to keep the hearing record open to send in that written documentation, we're going to go by your sworn testimony that you did about 20 years ago, transfer the property into your name. So, there is that evidence in the record. Okay. So, Mr. Anderson, at this point, do you conclude your case in chief?
I mean, unless anyone has any more questions.
I don't think they do, Mr. Anderson. That's why I'm asking you if you had an opportunity to present evidence, you were cross-examined by the technical examiner. I don't have any questions for you. And Mr. Savage, the attorney for the applicant, doesn't have any questions to you. So does that conclude your case in chief?
Yes. If is there anything for me? So there's nothing else for me to say?
I didn't understand you. There's nothing else for you to what?
Is there nothing else pertaining to the case that you need me for?
Well, I can't give you legal advice. I'm the hearing examiner. I have to remain fair and impartial to both parties. But procedurally, I can tell you where we are in the case. Both parties, yourself and Mr. Savage, have presented their case in chief. Mr. Savage did have a rebuttal case. That rebuttal case included documents that are actually from you. You've seen those documents and the emails back and forth between you and Mr. Kaufman negotiating the lease. I'm sorry?
I do have one question.
Well, the question period, who's the question for?
Question is for Mr. Kaufman.
That ship has sailed.
Okay. The question is for the attorney who's representing Alpha.
Oh, okay. Go ahead. Go ahead.
Mr. Savage?
Yes.
Mr. Savage, this is what I would like to know. I know you're in contact and you've seen the emails and you've seen the different agreements because you introduced them into the rebuttal. Why is it that if Alpha was trying to do things in good faith and do things feasible for the both parties, the landowner who has interest and a say in what goes on, if they had intentions on making an agreement, or why didn't they relay that to me? I'm Warren Anderson. That I believe that you guys just grandstanded and never had and your landmen, you guys never had we're gonna do any lease. And you sent out the stuff to a dead man who couldn't answer you. And
Okay, Mr.
So my
Anderson, you want
question
me to answer that question?
can you?
Yes. So, Mr. Anderson, my review of the documents and the transactions and the communications. So, Alpha, on their review of the record of the title, they saw that Bobby Anderson was the owner of record at the time that they reviewed the title, the time that they sent out the well proposals. They sent it out that first well proposal in April 2025 to Bobby Anderson. Then, after additional due diligence, they discovered that Lily Anderson was likely an error, and also that you, Warren Anderson, were involved possibly involved in the ownership in some regard as an heir. So as a result, they sent a additional well proposal in June 2025 addressed to you and Lily. And then they engaged in good faith negotiations, which is shown by numerous email exchanges in an attempt to reach an agreement with you, in which you responded by email. So Alpha identified what you believed to be the owner, and that would be Lily, and possibly in some capacity yourself. You obviously are the spokesperson, representative for that interest, and that's who they dealt with in all those email exchanges. And
Mr. Savage?
Excuse me, I'm answering the question.
Just let me say, your guy, John Kaufman, said he never saw Lily Anderson on any records of file.
Is that a question?
No, I'm just what I'm saying is it's a question and a statement. I'm saying, how come your guy said that he never saw Lily Anderson on the paperwork? He only saw Bobby Anderson on the paperwork.
Yes, that was his initial title analysis. That was the initial title analysis, showed that Bobby Anderson was the owner of record, and there was not an official, as far as he determined, he did not see that there was official probate that had been filed or conducted. But fortunately, he was able to identify the correct owner and communicate with the correct owner, and that's Lily Anderson and yourself.
Sir, did you guys introduce the emails? Did you introduce the email from the first case, 24499, where I called him? I also sent him the email and told him, but they continuously sent Bobby Anderson, and we don't really answer Bobby Anderson's mail. He's been dead over 20 years. So for him to say, and you to say that you guys didn't know until June 2025, that's just a lie.
So, Mr. Anderson, that document of rebuttal exhibit number 3 shows that you marked up, they sent you a lease, they showed the terms of the lease, and you marked it up and gave counter offers on what you wanted. And that is clear evidence of good faith negotiations.
No, I don't think so. And I don't think that the rules that I read in the agreements that you guys signed in 2024 says that it's not saying you guys using you guys twisting the rules in the agreement that was signed with New Mexico.
I'm not sure what that question was.
So Mr. Anderson, this is the hearing examiner. I feel like you've made your point. Mr. Savage is not a witness, so what he says is not evidence. Only the people sworn in today, Mr. Kaufman and yourself and Mr. McLean, who didn't testify at all today. Only that is evidence that we can consider, along with the exhibits that have been admitted into the record. So I think we have enough to go on at this point to make a determination. So when it comes to closing arguments, I'm going to give each party 3 minutes. So Mr. Anderson, you'll have your final opportunity to say what you want, but it will be strictly timed to 3 minutes. And we're going to start with Mr. Savage. It's 10:13 a.m. Go ahead.
Okay. So Mr. Hearing Examiner, Mr. Technical Examiner, the record shows that, first of all, in the motion that we filed, it spells out what the legal criteria is for satisfying attempts to reach a voluntary agreement. And that was adjudicated in order and issued in order R21679 -C. And in that particular case, the negotiation requirement under the Oil and Gas Act was satisfied by sending out a well proposal with the offer just in the well proposal and then one email exchange that addressed a question but did not give an additional offer. So the OCC, the commission has ruled on that. Now, in comparison with what Alpha has done, they sent out a well proposal to Bobby Anderson, the owner of record, as they saw it. And then through due diligence, they identified Lily Anderson and the involvement of Warren Anderson, and they sent out an additional well proposal to address that. That provides the offer. And then they exceeded the requirements of the commission's ruling on what satisfies and attempts to reach a voluntary agreement by approximately over 23 email exchanges. During these email exchanges, they made offers of 25% royalty, which is twice as much as the statutory royalty under a pooling, and it's also higher than the fair market value. They also offered 5,000 signing bonus, and for a 0.2 net acres, that comes out to be about $18,000 per acre, which is well above the fair market value, which is estimated around $15,000 per acre in this area. So that demonstrates good faith negotiations and an offer. Now, you had an opportunity to accept that. If you did not accept it, Alpha satisfied its requirements to go to a compulsory pooling. Alpha satisfied the pooling statute because an agreement was not reached. And when an agreement is not reached, the OCD has the authority to review the request for a pooling. And that's where we are today.
Thank you, Mr. Savage. That's 3 minutes. Mr. Anderson, you have your 3 minutes now.
Okay. What I would like to say to that is, you're saying that you dealt in good faith and you satisfied the burden of proof when you you didn't deal in good faith, and we also objected to trying to push a 3-year lease into a 5-year lease, and I mean, that's our property. We have interest, and we don't have to agree with you on that. And what I will say is, we're going to definitely appeal and file with the court, because this what you guys are doing here and saying here is not right. And your guy lied. And I don't know if you were ever going to try to do an agreement. If I have 10 bubble gums and other landowners have 1,000 bubble gums, you can't offer me the same thing, because I have to sell my bubble gums at a higher price. They can go with 5,000 because they got 1,000 bubble gum. So that's simple at a layman's term. So all I'm saying is, under false pretenses, by stating that they were not able to get in touch with us, the property owners, however, we have respectively emailed both Alpha Energy Partners and Legacy Onshore through this whole ordeal. And we've always been above board and tried to make some type of feasible deals with Alpha, so they can't say that we're not cooperating or trying to cooperate with them. And like John Kaufman said, he would like to make a deal. We would like to make a deal. But at this time, we can't we can't make a deal. And I don't think that they should be pulling us. That's that's the answer.
Okay. All right, Mr. Anderson, thank you. Thank you for your participation today. You've given us some information to think about. And thank you, Mr. Savage. Appreciate your participation as well. Thank you, Mr. Kaufman, Mr. McLean, for being here today and testifying. If there's nothing else, Mr. Savage?
Unless you want to hear from the geologist or Mr. McClure wants to ask any questions regarding the geology of it, I'm finished.
Okay, Mr. McClure?
I have no questions for the geologist in this case, Mr. Hearing Examiner.
Thank you very much. All right, then that concludes our business here today. This is the only case on our docket today, so hope everyone has a good day, and we're off the record.
Thank you.
Thank you, sir. Thank you.